You ever wonder how a lawyer proves that one specific factory caused your cancer when thousands of people near that same smokestack never got sick a day in their life? That question sits at the center of some of the messiest injury cases out there, and it is way weirder than anything you learned in science class. Here is the twist nobody tells you. Most injury law works like a simple math problem. You slipped, they forgot to mop, you broke your wrist, done deal. But widespread exposure cases do not work that way at all. Think asbestos, contaminated water, or a chemical plant leaking into a whole neighborhood for 20 years straight. Nobody can point to one single moment and say that is the exact instant the damage happened. Instead, lawyers have to talk in probabilities, like a weather forecaster saying there is a 70% chance of rain instead of promising you an umbrella emergency. This is where something called epidemiology waltzes into the courtroom looking very out of place. Scientists study huge groups of people, compare the sick ones to the healthy ones, and calculate whether your exposure made your odds of getting hurt jump way higher than normal. Courts came up with a rule of thumb called relative risk, and if the number crosses 2, that basically means you are more likely than not harmed by the exposure. It sounds like a video game stat, but it can literally decide whether your case moves forward or gets tossed out. Now here's where people get confused, thinking one blood test or one doctor's note magically proves everything. In these mass exposure cases, no single piece of evidence carries the whole argument. It is more like assembling a jury of clues instead of one smoking gun. Lawyers pull medical records, exposure timelines, workplace logs, and even historical company memos that sometimes read like a corporate horror movie script. Picture a 1976 internal memo basically admitting the chemical was dangerous while the company kept selling it anyway, because apparently profits do not read warning labels either. You also have to deal with something called the latency period, which is a fancy way of saying symptoms can show up decades after exposure. That is why some of these cases involve people who got sick in 2023 from something that touched their lungs back in 1989. This is why good injury lawyers basically become part detective and part historian. They are digging through old records like it is an archaeology dig, except instead of dinosaur bones, they are finding evidence buried in warehouse basements and microfiche archives. Doubt shows up constantly in these cases, both from juries and from the people suing. You might think, how can anyone be sure it was that plant and not just bad luck or genetics? And honestly, that doubt is fair, which is exactly why the statistical models exist in the first place. Some communities have banded together to demand transparency, and honestly, that grassroots pressure has changed outcomes more than people realize. When neighborhoods start comparing notes and health records, patterns emerge that no single family could have spotted alone. The lesson here is not that every mysterious illness means lawsuit time, it is that patterns matter more than panic. Rational thinking means looking at data first, then deciding whether your situation fits a real pattern instead of chasing shadows. If you or someone you know has been exposed to something suspicious over a long period, this is exactly the kind of murky, high-stakes situation where having the right legal team actually changes the math in your favor. Preparation beats confusion every single time, especially when the truth is hiding in decades-old paperwork instead of one dramatic accident scene. Want to learn more about how we help people navigate cases just like this? Check out our links in the description.